24-059. We are scheduled to begin today's hearing at 1:30. Well, I've made some time for the attorneys to speak with their clients as well as to speak with each other. Okay, sorry, we've actually begun the court hearing, so let's try not to do too much interrupting. Ms. Spencer has just informed us she has a 3:10 hearing. I certainly hope that with the time that we had this afternoon, that all of you have been able to come to some good conclusions, and I look forward to the updates on how the case will be proceeding. May I have appearances, please?
Lee Heiss, lawyer guardian ad litem for the children.
Nastasia Thomas, counsel for the department. I believe Ms. Jones and Ms. Grant are present. Ms. Jones was our investigator, and Ms. Grant will be our ongoing worker.
Chelsea Grant, ongoing worker for the department.
Amanda Jones, the CPS investigator.
Good afternoon, Charles Noe, appearing on behalf of respondent mother. State your name, please.
Oh, sorry. Faith Double. Mother.
Mr. McFarland?
Michael McFarland, appearing on behalf of one respondent father. Please state your name. Jeffrey Patterson.
I'm sorry?
Jeffrey Patterson.
Thank you. And Ms. Spencer?
Alexis Spencer, appearing on behalf of respondent father Austin Doobie.
Mr. Doobie?
Yes.
Could you give us your name for the record, please?
Austin Doobie.
Thank you. All right. Thank you. All right. Ms. Spencer, let's start with you. Have you reviewed the petition with your client? Do you have any reason to believe that he would need that read onto the record today, or do you know if he wants to waive that?
Yes, we can waive reading. I did go over it with my client. Thank you.
Very good. And are you aware of whether or not any other cases other than those previously disclosed apply to concern any child of your clients?
No, only the ones listed.
All right, very good. Do you know whether or not your client has any Native American heritage or reason to believe that he or his child would be eligible for tribal membership?
He did not inform me that that was the case.
You go over that with him once he's sworn. And how would you like to proceed?
He would like to enter a no contest plea and accept the case service plan.
What would be the basis for the no contest plea?
So there are some criminal, there is a criminal action right now that he was obviously in jail for at the time of the first hearing that he was not here for. So he obviously does not want to admit that he did anything in that case that could be used against him.
Yeah. Any objection to that, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No.
Mr. Noe?
None.
Ms. Heiss?
No objection.
All right. Very well. Let's go to you next, Mr. McFarland. All the same questions?
Yes, my client does waive reading of the petition, Your Honor. We wish to enter no contest plea based upon number 38, which are assault allegations against a minor child in this case, Your Honor. Specifically A, B, and C.
Have you inquired of your client as to whether or not there are any other reason, if there's no reason to believe that there's another case that applies?
No other cases.
Or whether or not he has any Native American heritage or reason to believe he would be eligible for membership?
And my client does, as we mentioned in court last time, they have some allegations of Native American heritage, Your Honor.
Very good. It does look like there were some inquiries sent, so we'll come back, we'll circle back to the department on that question. All right, Mr. Noe, does your client wish to have the petition read onto the record or waive that?
Let me waive, Your Honor.
All right, any other cases other than those previously disclosed that would concern her children?
None known, Your Honor.
Any reason to believe that she or her family members are members or could be eligible for membership in any Native American tribe or band?
Not that we know.
And how would you like to proceed?
Your Honor, my client would like to enter a plea of no contest based on one of the allegations, specifically numbers 11 and 12. In addition to that, my client would be in agreement to enter the case service plan with the modification of L being just adding the words at the end of it as enforceable against her. That was discussed with the counsel and also with Ms. Thomas. And I believe there's an agreement with that modification.
So she wishes to enter a no contest plea and to proceed to disposition immediately? Because we typically would have a 28-day time frame in between, and
No, that's fine. That's fine.
Your Honor, My client would like to proceed to disposition. He has reviewed the case service plan. I believe he signed that. Did not? Okay, well, he's read it. He's willing to go into the case service plan.
As is mine with the one modification.
And my client is,
Okay, all right, okay. Any objection to the no contest plea by the other two parents that you can pick up for any reason, Ms. Spencer, Ms. Thomas?
no objection.
No, Judge.
No objection.
Ms. Ice, do you find it to be in the child's or all of the children's best interest in this case for me to accept these no contest pleas and allow the case to proceed through disposition as well today?
Yes, Your Honor, the children are placed with Mr. Patterson and Ms. Double, and this would allow them to get started on their services quicker and quicker towards reunification and closing the case. Thank you.
Very well. Deputy Ames, if you could please swear in Mr. Jeffrey Patterson, Austin Doobie, and Ms. Faith Double. You're receiving right now a written copy of your trial rights, which I'll be going over with you verbally in a few minutes.
You can remain seated, but please raise your right hand if you're going to be sworn in, please.
Mr. Doobie?
Thanks. Sorry to give you two guys. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Okay, Mr. Doobie, do you have any Native Americans in your family or have any reason to believe that you or?
On my dad's side, yes, to do, I'm not sure, I'm pretty sure it was, I'm not sure the name of the tribe, but the originated in Muskegon and, around like the Lake Michigan area.
Great. Have you told Ms. Jones or Ms. Grant about those family members?
No, I have not.
Okay. Do you happen to have their names? Or do you know what their names were?
I know my father's name, Scott Allen Doobie, but,
Scott Allen Doobie?
Yeah.
All right.
Scott Michael.
Scott Michael Doobie, sorry, what was his mom, who was his mom's name? Because it was like, she was like.
He passed away when he was very young, right before he was a year old.
I don't know anything about that side of
I've not
my.
been in contact with the family since.
Okay. What is your name, ma'am?
I'm Abigail Bregman, I'm his mother,
Abigail, how do you spell your last name?
Brideman.
All right, Ms. Brigman, would you be able to speak with either Ms. Grant or Ms. Jones about any other information you have about the Native American heritage potential?
I don't really have a lot of information on that. I just, through word of mouth, is all I have. I don't really have any.
I could ask my,
Okay, one at a time, please. That's the other problem that we've got is we're trying to make a record, and although I have certainly a video available online, when Ms. Woodruff, if she has to do a transcript, it becomes very difficult when different people are talking at different times for us to follow that. So that's why I was asking if you wouldn't mind, Ms. Brigman, to just talk with Ms. Jones or Ms. Grant after today's hearing.
Okay.
Thank you, appreciate it. All right, very good. Okay, so all three parents, I am going to go over with you your trial rights. I have received your signed copies, which I appreciate. But I'm going to go over them. I'm going to go over your rights with you before I can take a plea today. If you accept or enter a no contest plea, you are giving up the right to a trial by judge or trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe can give testimony in your favor. Do you understand that you're giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition and enter a no contest plea, Ms. Double?
Yes.
Mr. Doobie?
Yes.
Mr. Patterson?
Yes.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court can terminate your parental rights. With regard to the plea itself, including a no contest plea, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. Double?
Yes.
Mr. Doobie?
yes.
Mr. Patterson?
Yes.
You have any questions about any of the information I've given you so far, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Is anyone making you enter a no contest plea, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Has anyone threatened you in order to get you to enter a no contest plea, admitting to the allegations today, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Outside the terms of the plea agreement, which to my understanding is essentially simply that you're entering a no contest plea, has anyone promised you anything to get you to enter a no contest plea, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this afternoon, Ms. Double?
No.
Mr. Doobie?
No.
Mr. Patterson?
No.
Would you say your decision to enter a no contest plea is one you've made of your own free will, Ms. Double?
Yes.
Mr. Doobie?
Yes.
Mr. Patterson?
Yes.
Very good. As it relates to the no contest plea, you will not have to verbally acknowledge any violation of the statute. That would be up to the department to make a showing that there's been a violation of the statute, and then I would decide whether or not to find that and accept your plea. However, you are effectively identifying the issues in the petition with the entrance of a no contest plea, and that is what the case services plan is built around, which I think I'm glad to hear that you've all had a chance to talk with your attorneys about that today, and that you at least indicated preliminarily that you understand what that's about, so that's good. All right, as it relates to the factual basis of the plea, Ms. Thomas.
Your Honor, typically I would ask for Ms. Jones to put that on record, but given the time constraints, I'm going to ask counsel if they would be agreeable to stipulating to the petition as filed to serve as a factual basis.
I would.
I would, but for number 30, it states that he is in jail and he's obviously no longer lodged there.
Sure, it's simply at the time that it was filed, at the time it was filed.
Yep.
Those were true.
No, Judge.
All right, very well. Ms. Heiss, do you find that to be acceptable?
Your Honor, I wonder if we could swear Ms. Jones and just have her attest that this is true and accurate. If she did sign it, you could accept that that is sufficient, but other than that, I do think that the facts laid out demonstrate what the family needs for services and how the case service plan will show a roadmap for reunification.
That sounds like a good idea. Ms. Jones, would you like to just step up to our podium for a moment?
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Ms. Thomas, would you like to lead that voir dire?
Sure, thank you. Ms. Jones, how are you involved in this matter?
I was the CPS investigator with the family.
Okay. And as the investigator, did you have the opportunity to speak with the family, have contact with the children, and review prior CPS contacts within the internal system?
Yes.
And did you sign your name to the petition that is in front of the court today?
Yes, I did.
And was that as a result of you drafting the petition that is in front of the court today?
Yes.
And under oath, do you affirm that the contents of the petition are true to the best of your knowledge?
Yes.
Okay, thank you. I have no further questions, Judge.
Ms. Spencer?
I have no questions. Thank you.
Mr. McFarland?
Can I ask a question about the case service plan, Your Honor, or
You may.
for that? As far as priorities on the case service plan for my client, where should his priorities be?
That would not be me. That would be a
You are correct,
Chelsea-
okay.
question for Grant,
I
Chelsea
have
Grant.
no- I have no questions.
Mr. Noe?
None.
Thank you. Well, Ms.
No questions, thank you.
Thank you. Okay, thank you, Ms. Jones. All right. Understanding that the factual basis for the plea then is simply the court taking judicial notice of the allegations in the petition. Counselors, are you satisfied with the advice of rights and the factual basis of the plea?
I am.
Yes, thank you.
Yes, Your Honor.
Yes, Judge.
Very well, thank you. The court is also satisfied there are indications of physical abuse, medical neglect, lack of supervision, and some other issues that have been well identified in the case services plan that's been engineered to help the parents understand both the effects that these things have had on the children, as well as how to develop some skills in order to create a better, safer environment for the children moving forward. I also find the plea to be knowingly, understandably, and voluntarily made by all three parents with a full understanding of the consequences that were reviewed on record today. Moving into the disposition, each of you have the right to have 28 days to meet with the department, to look at that case services plan and to have input on that plan. And then it would become part of the court's order moving forward. And it is how I am able to determine whether or not you're making progress in those areas that are barriers. So if you would like to proceed into the disposition today, you'll have to waive that 28 days. Is that what you wish to do, Ms. Double?
So
You 28 days. Whatever, 20 days.
that's not what I advised.
They've agreed to that. So you feel that that's-
Yeah.
Okay. Yeah, in terms of Ms. Double, again, the only revision we would ask, I don't know if the court has that, but is agreeable, but with that one revision, we're agreeable to the case service plan.
Do you have a version of the case services plan that you like, that your client would want to?
I had one before I came to court, but I've marked that up significantly. So I don't think that's gonna be acceptable to court.
All right. Well, it might be easiest then just to schedule our disposition. Which is perfectly fine. That will give you some time to look that over. And also you're welcome to begin your case services. If there are things that you want to get started on education-wise, some referrals for counseling or whatever that may be, you're welcome to get started on those before we come back.
That's fine, Judge, or I mean, I can also just submit to the department, it's an addition of 4 words to the end of one requirement of the case service plan. And that would resolve it today, but that being said, I understand the court's position as well, to be true.
Well, I appreciate that. Ms. Spencer, does your client have a case services plan that he wants to have entered today?
We were fine with the proposed case service plan. We did go over all of the, everything included on that, so.
Mr. McFarland?
My client was just to start the case service plan today, Your Honor.
All right, is there another copy of the case services plan for Ms. Double floating around anywhere that Mr. Noe could potentially use to accomplish his goals for today? Actually, maybe I have one. We're gonna look
I
at
have
it.
a clean copy, I just have one though.
That'd be fine. Thank you.
I do have a court report that was prepared for today, as well as some proposed case services plans as part of that packet. I'd be happy to hand those over. Deputy Ames, if you wouldn't mind taking those over. I would assume these are identical to the ones that have been previously circulated. Yes. There should be one for each parent, actually. Mr. Noe, did you find another copy somewhere else?
Yes,
I have
yes, the casework gave me 10 enough.
All right, very good. So Deputy Ames, there should be one for Mr. Doobie and one for Mr. Patterson. If the 2 of you could look those over, please. And if that is the case services plan that you wish to have the court enter, I'll need you to sign that, and that will become part of today's court order. I find further, for purposes of adjudication, that the factual basis for the plea has been met by the allegations in the petition, which I briefly visited on record, but there are certainly grounds to find that jurisdiction is appropriate.
Your Honor, I did just modify the one that was presented to me, present that to the court.
I'm sorry.
I just kind of hand wrote a modification on mine. Is that agreeable to the court to enter that?
It's okay with me if it's okay with your co-counsel. Which I think Ms. Thomas was nodding.
Yes, Shatter. I mean, as it relates to that specific element of the case service plan, the issue is ensuring that the department is only considering whether the parents are violating PPOs or no contact by the court order or issued by court order as it is enforceable against the respective parents. So we have that understanding. I'm happy to put that on the record, but I believe that handwriting that in or simply stating it for the record will suffice for my purposes.
All right, Mr. Noe, what is it that you wrote in?
Modifications of section L. It currently states state double agrees to follow all PPOs, no contact orders set by Lenawee County courts. I added as enforceable against her and initialed that.
Any objection, Ms. Thomas?
None.
All right, objection or position, Ms. Spencer?
I have no objection.
Mr. McFarland, any objection to the amendment that was just read onto the record by Mr. Noe?
No.
No objection, thank you.
Very good. Deputy Ames, if you could collect that one for me, I would appreciate
Then a signed copy to the bailiff, Your Honor.
Right.
All right, Mr. Doobie, I've received back a copy of the case services plan that appears to have been engineered for you. Is this your signature on page 3?
Yes.
You agree and you understand that you're bound to accomplishing these goals, and that will be what I'm gonna be looking at this moving forward. Do you understand that? Mr. Patterson, I'm looking at a case services plan that appears to have been engineered for you. It's a 2-page document that appears to have your signature on the 2nd page. Is that your signature? I'm sorry, what?
Yes, ma'am.
Thank you. And you understand and agree to be bound by these case services?
Yes.
Very good. Ms. Double, final question for you. Is this your signature on this page 2 with the modification?
Yes.
All right, and you understand that this is what you're gonna be bound to for case services moving forward?
Yes.
All right, very good. Do you wish to take any additional testimony on the court report or emails for purposes of the initial disposition, Ms. Thomas?
Your Honor, I think that given the time constraints today and that the parents are agreeable with the case service plan, the court report, actually, I'm going to strike that. I do need to take testimony from Ms. Grant to admit that court report, as it does have some of our ICWA documentation.
Ms. Grant, actually, why don't you just leave it where you are for now?
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. All right, go ahead.
Ms. Grant, we are looking at a court report that you prepared for today's hearing, and it also includes some ICWA documentation. As it relates to the case or the court report, are there any updates or modifications that you need to make to it on the record?
On the record, so the information for ICWA as it relates to that is updated for the most of information that I had until today in the court hearing about Austin's potential, although we did send ICWA documentation for his children also, I believe, to Cherokee, which is what that the updates were. I believe it was the Eastern Band. The only other amendment or update that I have is in the court report. It was talked about how the children were referred to early on. I did get those assessments this late in this afternoon before we got here. Did not have time to circulate it. I did bring enough copies for everybody, but I did get those referrals for early on.
And as it relates to the ICWA documentation, just something that I've noticed in my records that there's different spelling as relates to Mr. Jeffrey Patterson's name. How do you have it spelled in your system?
Jefffery.
Okay. Your Honor, may I inquire from Mr. Patterson if that is in fact the correct spelling of his name?
It is, Your Honor, I just asked.
Thank you. Okay. Well, with that, Your Honor, I have no further questions about the court report or the attachments. And move to admit them. Thank you.
Any objection, Ms. Spencer?
No objections, thank you.
Any objections?
Not to enter the court report.
No objection.
Thank you. They are received, the court report, the ICWA documentation, and then it looks like there's one other attachment, which is an ICWA report. And those will become a part of our court file, as well, of course, as the advice of rights forms. and the case services plans. Any other comments? For the record today, Ms. Thomas?
No, Judge, just asking for 90-day review. Thank you.
Ms. Spencer?
No further comments. Thank you.
I did have the one question of the worker about priorities for my client, if I might ask that.
Sure.
Thank you. I see you also have a psychological evaluation in the case service plan. Where should my client's priorities be and who schedules the psychological evaluation?
Sorry, we schedule it. I have been in contact with Dr. Haugen's office. However, he is scheduling out until July. We do have a second provider that I located. I reached out to her, but I haven't heard back yet. It is a psychological, I'm not sure how late she is scheduling, and I know that both of them want to get started sooner rather than later. If hers is sooner, she does do virtual, which would be easier, I think, on both of these clients due to work and the children in their care. And if that's the case, I'm going to make that ASAP.
As far as prioritizing in the case service plan, where would you expect my client to prioritize?
We're going to start with the psychological and the kids' trauma assessments. However, the oldest child's getting him re-enrolled in therapy is also part of the parents' highest priority.
Thank you. Thanks for it.
Questions, comments, Mr. Neri?
Thank you. I would kind of echo Mr. McFarland. I heard his questions and your answers. Would you agree the same questions, the answers would be the same for my client as well?
Yes.
Okay. No further questions then.
Very good. Any comments as far as the record goes for adjudication, prelim, or disposition that we've accomplished this afternoon?
Just a piece of housekeeping, Your Honor. I did file a limited appearance in this matter, and that was only through today's hearing. So I would ask that my client, obviously she has the opportunity to rehire me or get a different attorney or whatever. But until that point, I would ask that until that point, I would ask the court to appoint from the defender's office to represent my client following today's hearing. Obviously, you ends up retaining me further on or somebody else, that can change. But for today, moving forward, please.
Right. Ms. Heiss.
I have no closing, thank you.
All right. Court finds all interested parties are given notice for purposes of today's preliminary hearing and waive notice as it relates to the adjudication as well as the initial disposition. And that was well documented on the record today. The court will issue the preliminary hearing order, the adjudication order, as well as the initial disposition order with all of the case services plans attached as reviewed and signed by the parents today. The children will remain placed with the parents. That is the safest and least restrictive under the circumstances, especially considering that they're voluntarily and eagerly, it would seem, ready to get into case services plans, which is great. We're going to have our first regular review for all three parents on July 23rd at 9 o'clock in the morning. Unless there's any questions, that's all for today.
Your Honor, I do have one question.
Oh, I'm sorry, go
Just
ahead.
briefly, Your Honor, as relates to parenting time with Mr. Doobie, there was a prior court order that I believe Ms. Double was supposed to be exercising exclusive parenting time, from my understanding. And the recommendation is that parenting time remain suspended until there's engagement with services to ensure safety of the children. So if the court can just make a ruling on that part in its orders, would be grateful for the direction.
What is the position of the department on parenting time?
Right now, the court report from Ms. Grant indicates that we would seek for suspended parenting time for the time being until there's progress and benefit from services.
Is there a risk of harm associated with parenting time?
Your Honor, I admittedly do not have the prior court order up regarding how they ended up in this situation, but the contents of the petition also indicate inappropriate discipline and parenting skills.
Your response, Ms. Spencer?
Yes, I did discuss this with my client, and because the order from October 16th of 2023 signed by Judge Anzalone did suspend his parenting time until further order, we were fine with accepting that moving forward until he obviously gets his psychological assessment so that he can begin having supervised or therapeutic.
Very well. Ms. Spencer, if you come across something or your client is making progress and you'd like to revisit the issue of parenting time, I am also here. before you come back for your next review. So feel free to reach out to the guardian ad litem, who's very familiar also with bringing things to my attention in between hearings in the event that something changes.
Okay, perfect, thank you.
Ms. Heiss, would you agree with the position offered by your co-counsel?
Yes, I do, and I believe the agency's plan is to continue the visits with Mr. Doobie's parents, who are very bonded with the children, so that he will have some assurance that the kids are doing well through his family connections while he gets treatment or whatever he can do in the meantime.
That's great. Glad to hear that. Thank you. All right, I will include that then in the order. The suspension of parenting time would continue then until we come back for our next review, or until I've had something and you receive an order otherwise. I will not have the court orders for you immediately today, but they should be coming to you within the next few days. Any other questions?
That jury trial will be off then for the 22nd and 23rd.
Yes, but I will expect to see you back for the review on the 23rd.
My client says you can just mail him his order.